Is there any situation when domestic abuse could lead to the prevention duty being triggered rather than the relief duty? The reason I ask this is that I've seen a few cases recently when someone was subjected to current ongoing domestic abuse, and yet when I looked into what the council were doing, they were actually dealing with that person under the prevention duty. Now that might not seem very relevant, it might not seem that important, particularly if you agree with me that actually both the relief and prevention duties aren't actually very useful. But it's important to understand that the relief and prevention duty in one sense is a proxy code for, does the council think the person is homeless or threatened with homelessness? Obviously if the council satisfied they are homeless and the council satisfied they are eligible, then the relief duty kicks in, whereas the prevention duty kicks in if the council satisfied the person is threatened with homelessness, as in is likely to become homeless within the next 56 days, and the council satisfied they are in fact eligible. And it matters because interim accommodation, the Section 108 duty, does not kick in if you're threatened with homelessness. It only kicks in if there's reason to believe that you might be homeless, you might be eligible, you might have a priority need. And so the fact that someone is being dealt with under the relief duty would be evidence that the council is satisfied they are homeless and they are eligible, and assuming they are homeless because of domestic abuse and therefore in priority need, basically Section 108 is definitely going to be triggered. Whereas if they are being dealt with under the prevention duty, that basically says that the council hasn't realised they're legally homeless now, and it seems this can arise because council housing officers simply don't know what they're doing, and they get confused and they think that somehow that domestic abuse is a lesser form of homelessness, therefore they get the prevention rather than relief. So it makes no sense, but we see it happen fairly regularly. So I thought it just might be worth going into a bit of detail to see how this plays out in practice. I'm going to use a LGSCO case study that was actually cited in the Domestic Abuse Focus Report following the Domestic Abuse Act back in 2021, because it gives an example where someone would be threatened with homelessness and thus be owed the prevention duty because of domestic abuse. And you'll see what I mean in a moment when I explain the case. But just to really labour this point, if you are subject to current domestic abuse, it will not be reasonable to continue to occupy your accommodation, assuming you've not already fled it, and therefore it is a homelessness issue, not an issue of being threatened with homelessness. But the case I'm going to talk about is a Milton Keynes case. I'll put a link to the LGSCO decision on the description of the video just for you to have a look at it. It's interesting for several different reasons. It's a really good case actually if you want to learn how this all works. But in this particular case, the lady had approached Milton Keynes Council. Perpetrator was in prison, having been convicted of assaulting her previously. Not sure how long he was in for. And the question was, is she homeless? Is she threatened with homelessness? And one of the things the council basically got wrong is they said, come back when he's actually released and then we'll actually help you. And they definitely shouldn't have done that, because the perpetrator was about to be released. With prison releases, you're never quite sure when they're going to get released, because often you'll get a date and then it will change. Often they get released before the release date is actually given, because the government's trying to get people out of prison to free up space. And so it is, it's important that if you're in that situation that person makes a homeless application ASAP, certainly when it's anywhere near approaching that 56-day period of being threatened with homelessness. I don't think they even actually triggered the prevention duty, I might be wrong about that, but either way they basically said come back when you're actually homeless, come back when he's actually out of prison. This was based on an assessment from the police which said once he comes out of prison there's a very real risk that the abuse will continue. And so ordinarily that'd be a situation where that person will be threatened with homelessness because of domestic abuse, because although the abuse wasn't happening at that moment in time, it was likely to start happening once the perpetrator is released from prison. And that's, as I say, that's the only situation I can think of when someone who's affected by domestic abuse should be in prevention duty rather than relief. But as an interesting aside, in this case, the council should have actually gone further, because although this guy was in prison, he was writing threatening letters to her just to basically distress her and freak her out. He was also getting associates and neighbours to go around to harass her. And it's actually interesting with the language of the LGSCO, they use the word harassment and they fall short of that word domestic abuse. But in this situation, I don't see how it would fall outside the definition of domestic abuse. And therefore, at that point in time, although the perpetrator was about to be released within the next few months, she was legally homeless now, because although he was in prison, he was continuing to abuse her now. It was therefore, likely the abuse will continue while she remained in her home. Therefore, she was homeless. And so, in that situation, safe, suitable interim accommodation should have been offered immediately. As another interesting aside, she was on a joint tenancy in a council home or a registered social landlord, and the council basically didn't advise. They basically said if you give up that tenancy, you're going to be making yourself intentionally homeless. So then when she moved into interim accommodation, she kept the joint tenancy open, so she was still liable for rent, she was still liable for council tax, and she basically said the council never told me that I was liable for rent on both these properties. She basically just followed the advice. The council in the investigation said, yeah, we're confident we did do that. And the LGSCO said, you've got no proof of ever saying that. There's no contemporaneous evidence of you saying it. Therefore, we're going to assume that you didn't say that. And so not only did she get £1,000 compensation, but in effect, she was also going to get some money from the council to cover the rent arrears and council tax arrears that she'd accrued. So maybe it's worth another video, but basically whilst we're talking about it, in a situation where you've got a survivor who has fled her home, is in some other accommodation, hopefully interim accommodation, it's really important that you pay attention to any joint tenancies, any tenancies that's being held open. I've seen this done a couple of ways, both of which kind of resulted in a good outcome by councils. One was where the council basically said, look, just to belt and brace this, we advise you not to give up that tenancy until we've actually accepted the main duty, because there's always a risk that something happens and basically something falls through at the last minute. Now that's very unlikely in a situation involving domestic abuse, but I guess I see why the council said that. But basically they also gave advice about how that person would claim housing benefit for both, or universal credit for both their own property, their joint tenancy, and the interim accommodation, because it can be done. I think it can be done for up to 12 months, but again, don't rely on that. Check it out yourself if you're in that situation. And other situations I've seen where councils basically said from day one, look, the evidence that you're subject to domestic abuse is overwhelming. Although we can't issue a positive decision at this stage, take it from us, we're going to, and therefore that person gave up the joint tenancy straight away to avoid any kind of other problems that might arise from it. Because bearing in mind, the way the joint tenancies work is that, say the perpetrator came back out of prison and trashed the flat, because it's a joint tenancy, the survivor potentially would be liable for the damage that's done. Now in the real world, it's unlikely they're going to be held responsible, but it's a problem you want to avoid if you can. So yeah, hopefully that's useful. I think I've kind of covered the bases there. It's well worth reading this LGSCO decision, but in effect, just to summarise, the prevention duty should not apply in 99% cases of domestic abuse, because in 99% cases, they're already homeless. The relief duty should have kicked in, and if the council's correctly identified the fact that this person is or may be homeless rather than is or may be threatened with homelessness, the interim accommodation duty should also kick in, and that basically gives you time for that person to get safe accommodation whilst you figure out what else you need to do and kind of what other steps need to be made. So keep an eye out for it. If you see it in council records, it's basically a given that you're going to get compensation for it, because it's clearly maladministration. It would be evidence that that person has been left in the home at risk of further abuse when actually the council had a positive duty to provide safe accommodation for them.